Hi, this is Tony D'Amico. Thank you for joining me for this video on charitable and estate planning and looking at creating a lasting impact and significant tax savings. So, charitable planning and tax planning, one of my favorite topics because there's so much that you could do to support the causes that are important to you while generating potentially significant tax savings. So, let's jump in. So what is this video about? It's about financial management to help you achieve financial peace of mind and you create that lasting impact and legacy you desire. Here's a general overview of the session. Um, we're going to talk about estate and charitable planning that is effect only while you're alive. We're going to talk about taxes you pay while you're alive and also taxes that you pay after your death. So you do pay taxes, or somebody will have to pay taxes for you after your passing. We'll talk about estate and charitable planning that is in effect only after death. And most importantly, talk about tax planning and charitable strategies to maximize your impact. We'll also review some steps to ensure you have an intentional estate and charitable plan. Just a quick disclosure before we get started. As I mentioned, my name is Tony D'Amico. I'm the founder and CEO of Fidato Wealth, which is an SEC registered investment advisor. The one important thing that I want to review with you is that I don't know your personal financial circumstances. So I don't know if this applies, if this is, so don't take this as direct advice for you, because again, I don't know your situation. But nonetheless, I think you'll find this very helpful. And at the end of this presentation, I'll share with you how to schedule a complimentary introductory call if you want to learn more. So, what are some common motivations of estate and charitable planning? One is family values and legacy planning. Involving your children in charitable giving helps instill values of generosity and making a positive impact. So, one of the things I enjoy the most is that my family, we get together, my wife, son, and I, and every year we talk about the charities we've supported and who we want to give to next year. And also, we're very huge proponents of what we call boots on the ground. So, it's not just a donation, it's also being involved. So, this has been a great experience for myself and my clients, seeing them implement this with their family. Tax mitigation. Charitable contributions reduce your taxable income. It reduces capital gains and it reduces your estate taxes. So it significantly can lower your overall taxes paid. It allows you to advance faith in charitable based causes, whether again you're supporting your church or a charity or an other nonprofit initiative. A lot of folks that do charitable planning, they desire to make a dent in the world. They want to give to charities to support those in need or to advance certain causes or perhaps research. So charitable planning, it's not just about generosity. It's a strategic tool that combines faith or belief, legacy, financial benefits, and social impact. And it really helps individuals and families align their wealth with their values and long term legacy goals. What are some common barriers to being to making charitable contributions? One is not having a comprehensive plan in place and knowing where you stand, knowing that your needs are covered, that maybe your wants are all covered. When you have a comprehensive plan, you'll know where you're at, and it'll also see kind of the extra funds that you perhaps have. So super important to have that comprehensive plan that addresses all areas of your financial picture. Another common barrier is that someone has a comprehensive plan, but it's not being executed. So planning is something that occurs on an ongoing basis. So very important. It's important to note it could take 3 years or longer to have a comprehensive plan that's fully in place because there's cash flow, tax planning, risk protection, estate planning, charitable planning, college savings planning. So there's so many different facets. Again, charitable planning is not just about generosity. For some, it's about following biblical financial principles or sound financial principles that allow you to be generous in all areas. So, what estate planning is really about? It's really about getting clear on your values, your goal, and your goals and your purpose, which then informs your planning, which then informs your execution, which will then help you accomplish seeing your values advanced in both charitable efforts and the legacy you leave behind for the world and for your family. Providing clarity to empower your family and loved ones. Family harmony and family alignment, so important. Providing them the tools to steward resources. That's why it's really important. We call them family meetings, to have regular family meetings to review, especially your charitable efforts, maybe other planning that you have in place. Not necessarily your net worth per se, but you want to review what financial moves you have done. Perhaps it's getting a trust in place or a will in place or a tax analysis. Having those family meetings to educate them and having that centered around what we call a family constitution. And I think family constitutions are really neat. My family has one. It identifies our values, our goals, the principles that we adhere to, what behaviors exemplify those, and it really acts as a great guide. Okay, so let's talk about some basic estate planning, and we'll do this fairly quickly. And we'll also talk about more advanced estate and charitable planning as well. But estate planning allows you to maintain control over crucial financial decisions and personal choices. It helps you protect your legacy. And estate planning is needed by everyone, regardless of relationship status, regardless of employment status or net worth. It's needed by all to some level. Tax laws, do change. And when tax laws change, you often have to reassess your estate and your charitable planning. So one of the basic components of estate planning is doing estate planning that's effective during your life. And this centers around planning for your incapacity. Now, why is this important? Even if you're married, if you become incapacitated and you don't have these documents in place, a court-appointed individual will have to make those decisions for you. So the courts are involved. So when a life event occurs where you're incapacitated, you don't have that time, stress and delays. So that's why it's super important to have a healthcare power of attorney who designates who can make healthcare decisions for you in the case of your inability to do so, a living will, which indicates your intentions about being kept alive in the case of persistent unconsciousness, and a general durable power of attorney, which authorizes someone to be your attorney in fact and make financial decisions for you. Very powerful document. Healthcare power of attorney. Again, we review that, but again, it's going to allow somebody to make medical decisions for you on your behalf if you're unable to do so. You could provide instructions as well for your appointed agents for you. The living will, again, this will outline your preferences regarding life-sustaining treatments, sometimes called an advanced healthcare directive. You can also determine if you want to donate organs, fun stuff, right? The general durable power of attorney. This is, again, a very powerful document. You want to be very intentional to who and when you distribute this document to, because this authorizes somebody to act on your behalf as a kind of attorney in fact, and make financial, legal, and business decisions for you. Okay. So let's move on to the next slide, which is basically about tax planning. And this is a critical part of estate and charitable planning. Reducing taxes can make a large impact both while alive and after death, as well as for your estate and legacy planning. So without adequate planning, those opportunities may be lost and you can't go back. So very important to be forward thinking when it comes to tax planning in regards to your charitable efforts and your estate plan. A quick recap of taxes that we pay while we're alive. Federal income tax. This applies to both earned income and distributions from pre-tax assets such as IRAs, 401ks, and things of that nature. We pay state income tax in some states. Most cities have a city income tax. We pay property taxes, sales taxes. We pay tax on our investments. We pay, taxable ordinary income on interest and dividends, or we might pay a long-term capital gain. There's a net investment income tax of 3.8% that applies to certain types of accounts based upon certain modified adjusted gross incomes. Medicare premiums are income-based. So what you pay for Medicare once you turn 65 is based upon what your income was 2 years ago, and it rolls forward. But wait, there's more. Taxes we owe after death. You also will pay income tax, or whoever your executor is will pay your income tax bill for you. You pay tax on any income you earn during the year of your passing. Any income generated by your estate between your death and the distribution of your assets. Capital gains tax. So very important to note, when you're transferring appreciated assets, capital gains will vary depending upon when the assets were gifted. If you give the assets before you pass away, the recipient will be responsible for paying capital gain taxes on the full increase in the value. So they have to use what's called your cost basis. You give an asset to someone. So let's say you give a home to your one of your children, and you paid $200,000 for your house, but now it's worth $600,000, and they sell it. They have to use a $200,000 to determine their gain. Where conversely, if they inherit that home from you at death, they get to use the $600,000 cost basis. It's based upon the value of that asset on the date of death. There's a federal estate tax. Actually, in 2026, now the federal estate and lifetime gift tax exemption is 15 million. So in 2025, it was 14 million. 2026, I'm recording this on January 6, 2006. It's at 15 million. Now, if you have an estate that's greater than 15 million, any amounts above that are taxed at 40%. So if somebody is $1 million above that exemption, their beneficiaries have to pay a $400,000 tax within 9 months of the person's passing. So very important to note. Also here, it's important to note that the current estate tax has been made permanent. That was voted on in 2025, which made the previous tax cuts permanent. The only way that it could change, it will never sunset. It will change through Congress passing another tax bill. So it can change. It's never permanent 100%, but it's not going to what we call sunset. When tax bills, the first time the tax bill was passed, it was not by what was called a supermajority. A supermajority is required for a bill to become permanent. It was just a majority. State estate taxes. Ohio, Florida, and Texas, which are some primary states that I advise in, none of those have a state estate tax, but some states do. So do you want to know if you have an estate tax in your state? Gift tax. In 2026, an individual can give up to 19,000 per recipient annually without incurring any gift tax. So that also does not count against your $15 million lifetime gift tax exemption. Any gifts to a spouse or charity are generally exempt from gift tax. Taxes are our largest expense during life. So I'm going to give you some examples. And my hope is that you understand the impact of tax planning. You see what potential tax savings are involved. Because at the end of the day, you either choose where your money goes, or you can let the government entirely choose. And that's the essence of what you're doing when you combine charitable planning, estate planning, and tax planning. You're picking where your money goes. And again, when you make a donation to a charity, it can have significant tax savings. So let's talk about when these documents are effective. We talked about the durable power of attorney, healthcare power of attorney, and living will. Those documents are only effective during your lifetime. As soon as you pass away, those documents are null and void. Effective upon death would be your will, and if you have trusts, those are effective upon your death, and are still in force. So a will is a very important document. It outlines a person's wishes regarding their distribution of assets, care of any dependents. And it's also a critical part because it names your executor. Your executor will have some financial powers to handle your estate. So a very important designation to make. It's important to note wills are subject to probate. So you most likely will not want to rely upon just a will for your estate because it would be subject to probate. Some key elements of a will is the testator is the person who creates the will. The beneficiary is the person who receives the assets or property. The executor has the fun job of managing the estate, and then the guardianship is who is the legal guardian for any minor children. Some key functions of a will: ensures assets are distributed according to your wishes, prevents disputes, provides clarity and guardianship, and it speeds up the probate process. It doesn't eliminate it. So why do we have probate? We need a legal process at the state level to identify what people own, what the value is, and who has right to it, because sometimes people don't name beneficiaries. They don't have a will. They don't have a transfer on death deeds. All these things. So very important. So if you die without a will, your assets are distributed according to your state's law, and each state has a predetermined will for you if you die without a will. Or you can die with a will that you've created that's based upon what you want. And then probate will oversee the execution of your instructions. Why do we typically want to avoid probate? It's costly. It takes time, and there's a lack of privacy. These are public records. People could make claims to your assets, could be a creditor, could be whoever. Okay. So what are some ways to transfer assets out of, or have assets transfer outside of the probate process? One is how you title your assets. You can own something jointly with someone. If you pass away, then they're going to become the sole owner. You can own something jointly with rights of survivorship. You can have a transfer on death affidavit, for example, for Ohio real estate. I'll just actually use myself as an example. My wife and I own our home jointly with rights of survivorship. If we both get hit by the proverbial bus, we have a transfer and death affidavit that would transfer the house into our trust. You can name beneficiaries, another very powerful strategy. When you when you when you pass along an asset via a beneficiary designation, it's called passing by contract. That asset will go to the beneficiary named. So your beneficiary document is very powerful. And speaking of, there was a Supreme Court ruling on a plan beneficiary form. Kennedy sued the plan administrator for the DuPont Savings and Investment 401k plan. So here's some key details. William Kennedy's ex-spouse received his $402,000 retirement plan because she was the named beneficiary. He died in 2001. They were divorced in 1994, and his ex-spouse waived her rights and any benefits from the retirement plan. They both wanted the proceeds to be paid to their daughter, but she failed to change the benefit. But he failed to change the beneficiary document. And what the Supreme Court said is your beneficiary form supersede everything, regardless of what a will, trust, divorce decree, or any other signed document might say. Okay, so let's talk about trusts. Trusts are a powerful charitable and estate planning tool, and a trust is a legal arrangement designed to hold, manage, and distribute assets based upon the terms and conditions that you set. These terms can offer very wide guardrails or sometimes very narrow guardrails. It all depends upon the situation that is being planned for. Some key definitions: the grantor is the person who establishes the trust and transfers assets into the trust. The trustee has the fun job of managing the trust's assets. They have a fiduciary duty. The beneficiary is the person who receives the benefits of the trust, and the trust agreement is the formal legal document that spells out all the details. So what are some benefits of trust? It does avoid probate. It ensures the transfers of assets outside of probate. You can use it to balance inheritances, simplify the distribution of assets, protect assets from creditor claims. It allows you to give tools and resources to somebody who may lack financial responsibility or experience. You can also delegate responsibilities to key advisors such as wealth advisors, CPAs, attorneys, and have those folks listed in your trust. And trust can also reduce taxes. So trusts are either revocable or irrevocable. A revocable trust provides the grantor the most flexibility because they can amend or even dissolve the trust at any time while they're alive. Now, a revocable trust will become irrevocable at the grantor's death. While the grantor is alive, they can serve as both the trustee and the beneficiary. So a very helpful tool. Irrevocable trusts are, I would say, completely different. They cannot be changed or terminated by the grantor once they're established. The grantor relinquishes control over the trust and its assets upon creation. Irrevocable trusts are used to reduce or eliminate income and estate taxes and for creditor protection. Irrevocable trusts, excuse me, irrevocable trusts have some great benefits. They also have some cons. Again, you're relinquishing control of your assets. But it can save a lot in income and estate taxes when used appropriately. Irrevocable trusts also include charitable remainder trusts. So we'll talk about that as one example. So revocable living trusts, I can actually just use myself as an example. I have a revocable living trust. Um, it, it the purpose of that would be for my wife's benefit. If I predecease her, she has a trust as well that's set up the same way. And then once we're both gone, the trust is for the benefit of our son. It lists in there what age he needs to be the trustee of his trust, how we desire the funds to be utilized. So there's guidelines, there's wide guardrails in our particular situation. There's resources in there to provide him with the tax, legal, and financial counsel that'll be needed. And this is all there to, again, promote our family values, promote family harmony, and empower the next generation to make the best decisions. And that's what I see with the clients I work with as well, right? Okay, we mentioned that the grantor for a revocable trust can amend terms. It avoids probate. Now, a revocable trust does not shield assets from creditors, and it does not provide any income or estate tax savings. A pour over will is typically a good idea, not always, but a pour over will can transfer any remaining assets outside the trust into the trust upon the grantor's death. Again, irrevocable trust, very powerful, permanent in nature. You relinquish control, but it does come with tax benefits, creditor protection. There is flexibility with the trustee, but again, it's irrevocable by design. Okay, we already discussed these items here as well. Yep, we talked about the pros and cons again of irrevocable trusts, but if you want to read more, you can pause the video. All right, charitable remainder trust is a very powerful trust structure. Again, it's irrevocable. You make a gift to a qualified charity of your choice while generating an income stream for yourself. This can help you reduce or eliminate estate taxes, gift taxes, and probate. Key features, it'll provide you an income stream for your lifetime or your joint lifetime with your spouse or a chosen beneficiary's lifetime, which are taxed at individual rates, which is more favorable than trust tax rates. It offers a charitable itemized tax deduction for the year the trust is established. Upon your death or your beneficiary's death, the trust's remaining assets are transferred to the designated charity. The charity gift is exempt from gift taxes. The trust value is excluded from your estate for estate tax purposes. And if assets are sold in the trust, there's no capital gains, as the trust is tax exempt. However, capital gains may be taxable to a non-charitable beneficiary if distributed later. So what impact can this tax planning make? I'm going to review two examples with you. I'm going to skip to the second one first because we just talked about a charitable remainder trust. I obviously have changed some of the details, but there is a for confidentiality, there's a highly compensated professional that I work with. And he at one point, he was getting $5.5 million in restricted stock units per year that were vesting, and he was paying over $2 million in taxes. So he was charitably inclined. So what was the solution that we came up with in conjunction with myself, the tax planning CPA, and the estate planning attorney? He was very charitably inclined. He didn't need all of this money, but in running the math, running the numbers, the solution he came up with is he donated 4 million of his restricted stock units into a charitable remainder trust. He's able to get an income stream of $120,000 a year of income for about the next 50 years. And the actual present value of the remainder interest would be about 4 million. What does that mean? What does that mean? It probably sounds Greek. That means the donation was worth about 4 million. So that knocked out about $2 million of his income. It saved him $800,000 in income taxes. Extremely powerful. And it fit his situation of being charitably inclined and utilizing tax savings, combined with this lifetime income stream where it made financial sense all around. Another example I can give you is I'll call this person Bob, but Bob was making charitable contributions. So as he earned money, he would set aside money into a separate bank savings account. And then from there, he would donate to his church and charities. But that savings account at the bank was not tax advantaged. So Bob had accumulated like a couple $100,000 in this savings account. And I asked Bob, I said, Bob, do you need this money to live on? He said, Tony, no. As you could see, I have plenty of assets and investments and savings outside of this account that I've earmarked for charity. This is going to go to my church and the charities that I support. I said, okay. I said, Bob, have you heard of a donor advised fund? Bob obviously did not. And I explained to him that a donor advised fund is a fund an account that we can set up to create a charitable fund for him. And he can donate into it annually. And he said, that's incredible. I said, Bob, the thing is that instead of you putting cash into your bank savings account, you'll put it into this donor advised fund. And this will also allow you to itemize, because he wasn't able to itemize. So he got that benefit, but he was also in a top income bracket. So he said, well, Tony, if I put $100,000 into this donor advised fund, what will that do to my taxes? And I said, well, Bob, based upon your tax bracket, it's estimated to be a tax savings about 35,000. He said, so Tony, you're telling me that I'm going to put $100,000 into this donor advised fund, but it's only going to cost me 65,000 out of my own pocket? I said, exactly. Exactly. That is powerful. Now, to take this a step further, I said, Bob, instead of putting cash into this donor advised fund, you have these investments and these stocks that have appreciated significantly in value in this jointly owned account that you have. And instead of donating cash to the donor advised funds, what we'll do is we'll gift the appreciated securities from your $100,000 worth of them, of the most appreciated securities from your investment account into your donor advised fund. Then we'll take your cash and immediately replenish your investment account and immediately buy those stocks back, but at a higher cost basis. So now when he sells those positions in the future, he's going to pay much less capital gains tax. So it's hard to describe the financial impact. I should really model that out, because like that is a significant impact over someone's life. If you look at that impact over a 10, 20-year period, significant. So again, another story I'll share with you where charitable planning wasn't a good fit was someone who said, Tony, I want to set up a family foundation. And I was getting to know the person more and more. And what I found out is he wanted to set up this family foundation, which is a charitable entity, because he wanted to save money in taxes. But like, you don't do any of this just to save money in taxes. You do this because you are charitably inclined. This is the legacy you want to create. But can be significant tax savings based upon your situation. So it's always charitable intent first. Tax planning is 1B, to do it in the most tax efficient manner. Again, you choose your beneficiaries, or you can let the government decide. Um, so let's talk about ways to give. I'm going to do an overview of this, not going to review it all. I gave you an example of two strategies: a donor advised fund and a charitable remainder trust. A little bit more about the donor advised fund. So he's going to give to the charity right from that donor advised fund. So he and his church. So he can give directly from that. But once you put money in a donor advised fund, it's no longer you. You can't use it for your own needs. You can control the investments, and as long as you're giving the money to a 501c3, donor advised funds will typically approve that, and then it goes to that charity. So a very common tool that is used. So other things, we actually already talked about doing gifts of appreciated securities in combination with a donor advised fund. Another thing you can do is called a qualified charitable distribution. You have to be 70 and a half to do this, where you're allowed to take out so much money from your IRA, but give it directly to a charity, and the charity doesn't have to pay income tax on it. You can do private foundations. You're typically doing this for much larger amounts because there's more costs involved. So there's more costs, there's more administration. So it's typically for very, very large charitable efforts. Okay, so let's review the levels of estate and tax planning, and then we'll wrap up. Okay. In 2026, individuals can gift up to $19,000 per recipient. Again, not affecting their federal gift or lifetime estate tax exemption. So estate and tax planning is done in phases. Level 1 is the basic planning. This could be living trusts, revocable living trusts, powers of attorney, healthcare power of attorney, will, those types of documents. Once you go into level 2, that's where you're starting to use things like an irrevocable life insurance trust that, if set up a certain way, wouldn't be subject to estate taxes, taking advantage of annual gifting. Level 3 has to do with, typically business owners that can get valuation discounts on equity. Level 4 can be things like a qualified personal residence trust, a grantor retained annuity trust, an intentionally defective grantor trust. Very technical, but what the goal of all these, and lastly, real quick, is some folks have a zero estate. They want a zero estate tax. So they set this up where, hey, if there's any money that's going to be left to estate tax, I'm going to allocate that to a charitable remainder trust so I can get an income stream from it, and it goes to charity. The goal of all of this, all these different things, is to use them when they're beneficial. 1, to your family legacy, 2, your charitable intent, and there's tax savings, right? So all of these different strategies have that goal of those 2 examples of meeting your goals, but trying to maximize the tax benefit. Well, I hope you enjoyed this video. If you can't tell, I love this topic and would love to set up an introductory call with you that's complimentary. If you'd like to do so, go to calendly.com/TonyDemico/intro. You can also email me, Tony@FidatoWealth.com. You can check us out at FidatoWealth.com as well. Thank you very much for joining me. I hope you found this of value.